Contract law at your fingertips. Welcome to our channel, Law Rod. Today we dive into the essential elements of a contract. A contract is defined as an agreement made with the free consent of parties with capacity to contract for a lawful consideration and with a lawful object with the intention to be legally bound. The definition is in reference to Section 9 of the Contracts Act, Chapter 284, Laws of Uganda. Note that a contract may be oral or written, or partly oral and partly written, or may be implied from the conduct of the parties. A contract, the subject matter of which exceeds 25 currency points, shall be in writing. This is in reference to Section 9, Subsection 5 of the Contracts Act, Chapter 284. Let's now dive into the essential elements of a contract. The essential elements of a contract are 1. Agreement. An agreement is formed when one party accepts the offer of another and involves a meeting of the minds. An agreement is formed when one party accepts the offer of another and involves a meeting of the minds. The second element of a contract is consideration. The mere fact of an agreement alone does not make a contract. Both parties must have provided a consideration. That is, each side must promise to give or do something for the other. Consideration means a right, interest, profit, or benefit accruing to one party, or forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other party. The definition is in reference to Section 1 of the Contracts Act, Chapter 284. Lash J. in Curry versus Misa referred to consideration as consisting of a detriment to the promisee or a benefit to the promiser. The definition given by Sir Frederick Pollock, approved by Lord Dandin in Dunlop versus Selfridge Limited, is an act or forbearance of one party, or the promise thereof, is the price for which the promise of the other is bought, and the promise thus given for value is enforceable. The third element of a contract is intention to create legal relations. The parties must have intended the agreement to have legal consequences. The law will not concern itself with purely domestic or social agreements. Social and domestic agreements are agreements between family members, friends, and workmates. The law presumes such agreements not intended to be legally binding. See Lenz versus Devonshire Club. For example, agreements between a wife and a husband living together as one household are presumed not to be legally binding unless the agreement states to the contrary. A case study in reference is Balfour versus Balfour. However, the presumption against a contractual intention will not apply where the spouses are not living together in amity at the time of the agreement. A case study in reference is merit versus merit. In business or commercial agreements, the presumption is that the parties intended to create legal relations and make a contract. However, this presumption can be rebutted by the inclusion of an express statement to that effect in the agreement. A case study in reference is Rose and Frank Company versus Crompton Bros. Limited. The fourth element of a contract is form. In some cases, certain formalities, that is, writing, must be observed. Section 9, subsection 5, and subsection 6 of the Contracts Act, chapter 284, Laws of Uganda, provides for the contract whose subject matter exceeds 25 currency points and the contract of guarantee or indemnity to be in writing. The fifth element of a contract is capacity. Don't forget to find out our video on capacity to contract in our channel, Low Road. Now, capacity as our fifth element of a contract. The parties must be legally capable of entering into a contract. See section 9, 10, and 11 of the Contracts Act, chapter 284. The general rule of the English law is that any person is competent to bind himself to any contract he chooses to make, provided that it is not illegal or void for reasons of public policy. However, at common law, there are exceptions to this rule. In the case of corporations, minors, married women, mentally incompetent, and intoxicated persons. For example, a corporation created under the Companies Act, Chapter 106, has the same contractual capacity as an ordinary person. However, it can only make such contracts within the scope of its objects set out in the Memorandum of Association. Anything beyond that is ultra-vires and void. In the leading case, Ashbury Railway Carriage and Iron Company Limited versus Richer, the directors purchased a concession for making a railway in Belgium and purported to contract with Richer that he should have the construction of the line. Rich's action for breach of the alleged contract failed, since the House of Lords held that the construction of a railway was a distinct from rolling stock, thus who travails the company, and therefore the contract was void, for it was an act which the company had no power in law to do. The sixth element of a contract is consent. The agreement must have been entered into freely Consent may be vitiated by duress or undue influence. See sections 12, 13, and 15 of the Contracts Act, chapter 284. The seventh element of a contract is legality. The purpose for the agreement must not be illegal or contrary to public policy. A contract which possesses all the seven elements as discussed, that is, agreement, consideration, intention to create legal relations, form, capacity, consent, and legality, is said to be a valid contract. In conclusion, the absence of an essential element will render the contract either void, avoidable, or unenforceable. In addition, a contract consists of various terms, both express and implied. Do not forget to come back to our first channel and find out a video on express and implied term. A term may be inserted into the contract to exclude or limit one party's liability. A contract may be invalidated by a mistake, and where the contract has been induced by misrepresentation, the innocent party may have the right to set it aside. Note that, as a general rule, third parties have no rights under contract, but there are exceptions to that extent. There are different ways of discharging a contract, and remedies are available for breach of contract at common law and equity.